All right, so today we're diving into some pretty fascinating legal territory. We've got this lawsuit, Brittany Henry and Shania Richmond against GEICO and Assurant.
Go ahead.
And it all starts with a canceled renter's insurance policy, but things get a lot more complicated from there.
Yeah, it really kind of spirals out from there, doesn't it?
Yeah.
What's really striking about this case is how it starts as a seemingly simple insurance dispute. Something a lot of people can relate to.
Right.
But it quickly uncovers these potential issues with, corporate practices and even regulatory oversight.
Yeah, and, we've all dealt with insurance companies at some point in our lives, right?
Of course.
But the way this case unfolded just raises some serious questions about how these companies actually operate.
Yeah.
And whether the agencies that are supposed to be overseeing them are actually doing their job and fulfilling their duties.
Absolutely. And the plaintiffs in this case, Henry and Richmond,
right.
They allege that GEICO and Assurant weren't even acting as insurance companies in the first place, despite issuing their policy.
Wait, hold on. How is that even possible?
Right.
I mean, these are two of the biggest names in insurance.
I know. And that's what makes this case so intriguing.
Okay.
The defendants' law firm, Kavanaugh, they actually argued that Assurant wasn't involved in any of the typical insurance functions at all.
Like, what do you mean?
Like underwriting or collecting premiums, or even handling policy cancellations or claims.
Well, wasn't their policy managed through Assurant's website?
Yeah.
myassurantpolicy.com, that whole thing.
Exactly. And the policy documents even included instructions on how to contact Assurant directly.
Right.
So the plaintiffs pointed to all this evidence, which, on the surface seems to directly contradict the defendants' claims.
Yeah, it does.
And under Arizona law, the Arizona Department of Insurance, the DOI,
right.
They're actually obligated to investigate claims like this.
Okay.
They have a duty to protect consumers.
So what did the DOI do? Did they launch an investigation?
Well, that's where things get really interesting.
Okay.
Despite multiple public record requests and emails from the plaintiffs, the DOI just remained completely silent.
Oh, wow.
No response, no investigation, nothing.
So that's concerning, right? It's like having a watchdog that's just asleep at the wheel.
Well, it certainly raises questions about, the effectiveness of the regulatory oversight here, but this is really just the beginning of the story.
Okay.
The plaintiffs, they decided to look into the corporate records of GEICO, Assurant, and this other company that was mentioned in their policy called American Bankers Insurance Company.
Okay.
They went straight to the source, the Arizona Corporation Commission Records Office.
Okay. And what did they find?
Well, GEICO and Assurant, they were listed as foreign corporations, which is, pretty standard for companies that do business in multiple states.
Right.
However, American Bankers Insurance Company wasn't listed at all.
So this company that's, named in their insurance policy and seemingly plays a role in their coverage wasn't even registered to do business in Arizona.
That's what the plaintiffs found. And based on that, they filed a judicial notice.
When was this?
October 15, 2023.
Okay.
Officially confirming, the absence of incorporation.
So it seems like they were trying to bring this to the court's attention.
Yeah.
So like, hey, look, there's something off here.
Exactly. But the defendant's law firm, Kavanaugh, they vehemently opposed this disclosure, trying to prevent the information from becoming public record.
Okay, so we've got a company that's potentially operating without proper registration, and the defendants are fighting to keep it quiet.
Yeah.
What happened next?
Well, on October 30, 2023, just a week after the plaintiffs filed their judicial notice, the Arizona Corporation Commission just completely refused to release any further documents on either GEICO or Assurant.
What was the reasoning behind that?
They claim that they received a direct order from the DOI to withhold the information.
Wait, so the DOI, who initially just ignored the plaintiff's request for an investigation, is now stepping in to block the release of public records.
It seems that way.
And this is all happening right after the plaintiffs filed this legal document that could potentially expose some questionable business dealings.
The timing is certainly peculiar, wouldn't you say?
Peculiar is an understatement. I mean, it seems like the DOI went from 0 to 100 real quick.
Yeah.
Going from being completely unresponsive to taking this very decisive action to protect these companies.
It definitely raises even more questions about the DOI's role in all of this. Are they truly acting in the public's best interest, or are they more concerned with protecting these companies that they're supposed to be regulating?
It's a troubling thought, for sure.
Yeah.
But before we get too deep into the implications of the DOI's actions here, let's unpack this issue with American Bankers Insurance Company not being incorporated in Arizona. Like, what does that actually mean, and why is it such a big deal?
Yeah. Well, it's a significant issue because it raises all sorts of questions about whether American Bankers was even legally authorized to conduct business in Arizona in the first place.
Mm.
And whether its involvement in the plaintiff's insurance policy was even legitimate.
Oh, wow.
So it really challenges the validity of that whole insurance arrangement.
So you're saying that even though American Bankers is named in these policy documents,
Right.
it might not have actually had the legal right to issue or participate in that policy in Arizona.
Exactly. And that opens up this whole can of worms
Yeah.
legally, about the enforceability of the policy, the liabilities of all the parties involved. It gets messy.
And wouldn't the Arizona Department of Insurance be responsible for making sure that companies operating in the state are properly registered and, actually following the law?
Absolutely. The DOI has a very clear mandate to regulate the insurance industry and to protect consumers from these kinds of, unlawful or unethical practices.
But as we've seen, their actions in this case seem to completely contradict that mandate.
Right.
I mean, they failed to investigate the plaintiff's initial claims, and then they actively stepped in to prevent the release of public records
Yeah.
that could have shed some light on American Bankers' status.
It's a pattern of behavior that at the very least seems to put the interests of these insurance companies ahead of the policyholders.
Right, and that's concerning.
Yeah.
And this whole thing with American Bankers potentially being unregistered just adds another layer of complexity to this already pretty convoluted case.
It does, and it really underscores how important transparency and accountability are in the insurance industry.
Yeah.
Policyholders, they deserve to know that the companies they're entrusting with their, financial security are operating legally and ethically.
Absolutely. So we've talked about these missing incorporation records and the DOI's actions, which are definitely questionable.
Mm-hmm.
But let's zoom out for a second and look at the bigger picture here.
Okay.
What does this case tell us about the potential for what's called regulatory capture in the insurance industry?
Well, I think it's a perfect example of how regulatory capture can actually play out in a real-world scenario.
Right.
So for anyone who needs a refresher, regulatory capture happens when a regulatory agency, like the DOI in this case, becomes more aligned with the interests of the industry it's supposed to be regulating than with the public interests.
Right. It's like the watchdog becoming best friends with the wolf.
Exactly. And in this case, the DRI's inaction when faced with these potentially illegal activities and then their efforts to actually block the release of public records raises some serious concerns about whether they're really fulfilling that duty to protect consumers.
So what are the consequences of regulatory capture in a situation like this? I mean, obviously, the plaintiffs have been negatively impacted.
Right.
But are there broader implications that we should be thinking about?
Absolutely. I mean, regulatory capture can really undermine the entire system of consumer protection.
Wow.
When the agencies that are responsible for overseeing these industries get too cozy with them. It creates this environment where unfair and potentially harmful practices can just thrive.
And in the case of insurance, that could mean that companies can get away with denying legitimate claims or charging these crazy high premiums.
Yeah.
Or even operating illegally without any real consequences.
Exactly. And that's why this case is so important. It shines a light on what can happen when regulatory agencies fail to act in the public interest.
It's a reminder that we can't just assume that the system is always working for us.
Right.
We have to be paying attention, asking questions, and holding those in power accountable.
I completely agree. And it's also a reminder that we all have a responsibility to stay informed about how these systems actually work and to advocate for policies that promote transparency and accountability.
So based on everything we've learned so far, do you think there's a strong case to be made that the Arizona DOI might be experiencing regulatory capture in this specific situation?
Well, based on what we know, I'd say there are definitely some red flags here that need further investigation. Their lack of response to those initial complaints from the plaintiffs and then their efforts to prevent the release of public records really raises questions about their motives and their priorities.
Especially the timing of it all, right?
Sure.
I mean, they only took action after the plaintiffs filed a legal document that could have exposed some pretty uncomfortable truths about these companies.
Exactly. And that timing really makes you wonder if they were more concerned with protecting those companies than with finding out the truth and making sure that justice is served.
It almost seems like they were trying to just sweep it all under the rug.
It's a troubling thought, and it speaks to the power that these big entities have to influence regulatory bodies and to manipulate the system to their advantage.
So where does this leave the plaintiffs, Henry and Richmond?
Right.
What options do they even have when the agency that's supposed to be protecting them seems to be working against them.
Well, it's a tough spot to be in, for sure, but they're not completely powerless.
Oh.
They can continue to fight their legal case, trying to expose the alleged misconduct and hold the people responsible accountable.
But wouldn't that be a huge uphill battle, especially with the DOI seemingly siding with the defendants?
It definitely makes things more difficult, but it's not impossible.
Okay.
They can also use the power of public opinion, bring attention to their case and to this potential regulatory capture.
So shining a light on the situation and hoping that public pressure will force the DOI to act more responsibly.
Exactly. Public scrutiny can be a very powerful tool for accountability. And by bringing this case to light,
Yeah.
they're not only fighting for their own justice, but they're also raising awareness about a much bigger issue
Right.
that could potentially affect a lot of people.
It's a good reminder that we all have a role to play in holding these institutions accountable
Yeah.
and making sure that they're serving the public interest.
Absolutely. And I think this case also highlights how important it is to understand how these corporate structures and insurance regulations work. These systems can seem really complex and confusing,
Right.
but as we've seen, the details can have a huge impact on people's lives.
So let's dig a little deeper into the specifics of this case, particularly this whole issue with American Bankers Insurance Company and their unusual status as a Florida-domiciled surplus lines insurer.
Oh, okay.
What does that even mean, and why is it relevant here?
Mm-hmm.
Okay, Florida-domiciled surplus lines insurer.
Right.
It sounds like something straight out of a finance textbook.
Yeah, it's a mouthful.
Can you break that down for us normal folks?
Sure. So basically, a surplus lines insurer, it's a type of insurance company that's allowed to operate outside the normal regulatory framework.
Yeah.
In certain situations, they often handle these really unique or high-risk types of insurance that your standard insurers might not cover.
So like insuring a priceless work of art
Exactly.
or a rocket launch or something.
Yeah, stuff that's a bit more unconventional.
Okay.
And because they handle these specialized risks, surplus lines, insurers are given more leeway in how they operate, and they're subject to different regulations.
I see where this is going. So you're saying that American Bankers, as a Florida-domiciled surplus lines insurer, might have been playing by a different set of rules than a regular insurance company.
That's the big question here. And it's very possible that those rules don't require the same level of, corporate registration or oversight as standard insurers.
Which could explain why they weren't listed with the Arizona Corporation Commission.
Exactly. Their status as a surplus lines insurer might have allowed them to operate in Arizona without actually being formally incorporated there.
But wouldn't the Arizona Department of Insurance still be responsible for making sure that they were operating legally and ethically, even if they were under different regulations?
In theory, yes.
Yeah.
But the fact that the DOI stepped in to block the release of those public records about American bankers
Right.
suggests that they might be treating them differently.
It's like they're bending over backwards to protect them from any kind of scrutiny.
Yeah, and that perception just adds fuel to the fire when it comes to these concerns about regulatory capture.
So if American Bankers was operating under different rules as a surplus lines insurer, and the DOI knew about it
Right,
and was maybe even okay with it,
right.
what does that mean for the plaintiffs in this case?
Well, it definitely complicates their legal strategy. They're going to have to really dig into the regulations that specifically govern surplus lines insurers
Okay.
and determine if American Bankers was actually in compliance when they issued the policy.
And if they weren't in compliance, then what happens?
Well, it could open up the possibility of legal action against American Bankers and maybe even the DOI themselves.
So,
The plaintiffs could argue that the policy was invalid or that the DOI just completely dropped the ball on overseeing them.
so this whole surplus lines thing really throws a wrench into things.
It does. It just highlights how complex the insurance industry can be and how companies can operate in ways that most people wouldn't even realize.
It's like peeling back the layers of an onion.
Yeah.
And every layer you peel
Yep.
back, there are more questions and more potential for things to go wrong.
And that's why these kinds of cases are so important. They bring these issues to light and show how things can go wrong when systems aren't properly monitored.
It's a reminder that we can't just blindly trust that institutions are always looking out for us.
Right.
We need to be informed and engaged and willing to hold people accountable.
I couldn't agree more. This has been a really fascinating deep dive.
It has. We started with this seemingly simple case of a canceled insurance policy.
Yeah.
And we ended up uncovering this whole web of potential corporate maneuvering regulatory capture and these unusual insurance practices.
And we still don't have all the answers, but this case raises some really big questions about the balance of power between corporations, regulatory agencies, and the everyday consumer.
So to our listeners out there, what really stood out to you in this deep dive? As this case continues to unfold, keep in mind what it could mean for consumer protection and how important it is to hold these powerful entities accountable.
And remember, knowledge is power. The more we understand about these complex systems, the better we'll be able to navigate them and protect ourselves.
Until next time, stay curious, stay informed, and keep diving deep.